Some managers feel they can avoid wrongful termination claims by forcing employees to quit instead of terminating them. Creating intolerable conditions for the purpose of forcing an employee to quit is known as a constructive discharge and can lead to costly wrongful termination claims. Constructive discharge cases usually occur when an employer coerces an employee into resigning or intentionally creates a work situation that any reasonable person would find intolerable. In such cases, a court may determine that an employee is justified in quitting, and courts will treat it as if the employee was terminated. Consider this scenario. Rudy is an at-will employee in a junior engineer position. Although Samantha, the director of engineering, has long been dissatisfied with his work, she has never told him. Instead of placing Rudy on a performance improvement plan, Samantha makes his job miserable, beginning by transferring him to the night shift. Although Rudy quit his job, he may still have a wrongful termination claim if a court finds that he was justified in resigning. Creating an intolerable work experience for the purpose of forcing someone to quit is legally the same as firing them. If there is not good cause, the termination could be wrongful. Intentional infliction of emotional distress. All terminations are emotionally upsetting, but if a termination is carried out in a manner that is outrageous or would shock the conscience of a civilized society, it could give rise to a claim of intentional infliction of emotional distress against both the manager and the organization. When pursuing a claim for intentional infliction of emotional distress, an employee must prove the following elements. The employer acted knowingly or recklessly. The employer's conduct was extreme or outrageous. The employer's conduct was the cause of the employee's distress. The employee suffered severe emotional distress, usually medically treated, but not always, as a result of the employer's conduct. The following are examples of conduct that could be the foundation of a claim for intentional infliction of emotional distress. Assuming the employee develops some physical or mental affliction as the result of the conduct that is articulable and severe. Publicly humiliating employees, racial or sexual harassment, subjecting employees to intolerable working conditions to force their resignation. Intentionally falsifying work records or performance reviews to force an employee to quit or to adversely affect his or her employment. Consider this scenario. Tom, a bank manager, sees Janet, a teller, steal money from the cash drawer and leave the bank. The next day, when the bank is full of customers, Tom has two armed guards approach Janet with guns drawn. They handcuff her and lead her to Tom, who terminates her in front of the customers. Even though Tom has every right to terminate Janet for stealing, he does not have the right to do so in such a manner. The standard for emotional distress claims is conduct that is outrageous or would shock the conscience of a civilized society. Clearly, drawing guns and handcuffs in this situation would be excessive and sufficiently shocking to meet such a standard.